Hello, good afternoon, you all. My name is Francisco Poças from Startup Portugal, and I'm very glad that this webinar got your interest. I hope it will give you good insights and eliminate your doubts or uncertainties over the new startup law. In the next hour, we will overview and break down the new startup law that was recently issued on the 25th of May. To guide us through this groundbreaking document, we have the pleasure to have a distinguished panel of top experts from our community, and each one will focus on specific chapters of the new startup law. On behalf of Startup Portugal, thank you all in advance. While we are living in intense times and in a certain way unstable moments, Portugal is an attractive country and already a vibrant startup ecosystem that is building foundations to become one of the top players in the startup world. In fact, this new law is considered an important milestone for the startup ecosystem in the way that for the first time, we have a framework for the legal definition of startup and scale up. With this startup and scale up recognition, we will be able to map the ecosystem more accurately, and afterwards, we can produce legislation and public policies that target this particular ecosystem that, as we know, has such characteristics that distinguish it from the rest of the economy. Tiago Abade, head of public and private law from CCR Legal, will help us understand how the startup and scale-up legal definition works, its legal process, which companies are eligible for startup and scale-up recognition, and why is it important for our ecosystem. Next, we move to the second subject of the agenda, the employee stock option plan regime. Vasco Bívar Azevedo, partner from Cuatrecasas, will explain the mechanics and of the employee stock option plans. This new stock option regime is very important achievement for our ecosystem, mainly because now, in the new version of the ESOP, the employee only pays the tax on the moment of liquidity and not before as the previous one. Other than that, the new effective tax rate compares well with other countries in an even more competitive environment. Bruno Andrade Alves, individual taxation partner from PwC, will show us that, supported by the stock options benchmark, a study conducted by himself earlier this year, 2023. Moreover, Maria Gouveia, senior lawyer from Moraes Leitão, will break down the ESOP regime, elucidating us about the eligibility criteria and process, as well as the applicability of this new law. Maria will also explain us what are the virtual stock option shares and what's its importance and for the ecosystem and how these are addressed in the new law. Lastly, but not least, Paula, Pinho, and Marisa Lousada from KPMG will shed some light on how the SIFIDE fiscal scheme for innovative companies has been reformed, what are the main changes on its table, and how it can foster growth in innovative companies. So I will stop now, take no more precious time, and give word to this excellent panel to explore the potential and possibilities of the new startup law. So, Tiago, the stage is yours. Please give us your insight about the startup and scale-up legal definition.
Okay. First, I would like to thank everybody, and in particular to Startup to Portugal, to the invitation that made to us. It's really a pleasure to be here and speaking about the new law concerning startups, scale-ups, benefits. It's groundbreaking in Portugal, talking about a new law just concerning this area. That it's, of course, everybody can say that is a step forward, but I would say that is an important step forward. It's at this stage, the only thing we can go now, it's further. So we are on the first moment, so that is the important to emphasize and to address to all the work that Startup Portugal is doing and to the community. So understanding this and having lots of lawyers here today, and we love to talk, so I'll just have to speak within my 6-7 minutes that I have. My objective is to give you the principles to some of the concepts that the law brings. So the most important concepts that we just have to understand may we be for a company is concerning to the fact that what are the requirements for a company to be considered a startup or a scale-up company. So in here on this slide, what we present, all this information is going to be provided further to the people to the participants that want to know concerning what we are talking about. And I believe also Francisco already said that the video, the webcast is going to be possible to someone to see it later. So the important is not only to focus in all of the elements that I'm going to talk, but to understand that a company can be qualified as a startup or scale up if it is a legal person, it has activity for a period of less than 10 years, if employ less than 250 workers, if the company has an annual turnover that does not exceed 50 million euros, and of course, with these requirements, there are checks and balances, and the balance if it does not result from the transformation or division of a large enterprise and does not have in its capital and a direct or indirect majority holding of a large enterprise. So there is also a concept in Portugal concerning what is considered a large enterprise. So it has to be also addressed and evaluated to understand if startup, if the participation of another company, it can be a limitation to be considered a startup. It has also to have headquarters or permanent representation in Portugal, or at least 25 employees in Portugal. There is also considerations and requirements made to scale up. I understand that these requirements, in some aspects, that they appear to be clear, but there may be doubts concerning the overall. Of course, we don't have time to be concise, but maybe in the questions we may address on this. We have questions, but at the end we can address them. So, considering this, 7 minutes, lots of lawyers. Always remember this, and tax advisors and other people. So it's difficult. So, considering this, there is notions considering what is an innovative company. So there is still not only these requirements needed to be fulfilled, but there are other requirements that the company has to check. It has to check one of the following conditions: an innovative company with a growth potential of business model, innovative or products or services. There is an ordinance that qualifies this. A company that has concluded at least one round of risk capital. Of course, there is other considerations to be followed and understood. A company that has received investment from Banco Português de Fomento. So that may also be one of the requirements that, if it is fulfilled, may be added to the other requirements and fulfill the needed requirements to be considered a startup company, and a company holding a prior declaration issued by Startup Portugal based on an evaluation that will be fulfilled. Our legal understanding considering this, is that this is going to be addressed in the situations of needed to be evaluated that are not on the above situations and still is a startup company. So I would say that sometimes we call it a box of evaluation for other things that would not be addressed on the law initially, but of course it will have to be the framework of evaluation. It will have to be designed. So considering this next slide, and I'm just trying to finish within my timeline. In my next slide, the recognition, maintenance, and termination of startup and scale up, it's going to be managed by Startup Portugal. So the law indicates that Startup Portugal is going to be the entity in the name of that will have received competence from YAPME, and with this competence, Startup Portugal is the entity that is going to be responsible for the recognition. It should be a direct recognition, and the law states that we can require this certification by the single portal that exists in Portugal, that for all public entities, that is this Portugal, eportugal.gov.pt, that is a portal for all the public entities that it is addressed and combines all of the public entities that has some services. Considering this, there are some recognitions, certification documents that needed to be followed. Nevertheless, this recognition, maintenance, and termination of startup scale-up status is all the information that is going to be needed to be prepared, to be addressed and present by this portal to Startup Portugal. Also, Startup Portugal has the obligation to maintain a list on its own portal of all the entities that are considered scale-ups or startup companies. And this list, of course, it will be presented after the period of standstill that we are living on concerning the law. So next slide, and trying to be very fast. I think this is this is one of the most important ones, just to be aware of what should be done and what is being doing at this stage. It is the adequacy of the portal eportugal.gov.pt, where the documentation has to be fulfilled, because the law provides a standstill period between the publication of the law and 25th of November. So during this period, it is the period that the public entities have to prepare the information, prepare the technology, prepare the portal, prepare the information and facts to provide to the public entities. Why do I have here 25th of October? Because there is this administrative prerogative that combines the law that says that 30 days before, when we have this kind of procedures and regulation, it should be made public awareness for the implementation of the regulation up to before on a period before up to 30 days. So this is the deadline that the entities have to present the regulation and how to obtain the certification. So this is the first deadline, 25th of October, and on 25th of November forward, the entities can ask for the certification of a startup company.
Thank you, Tiago.
7, 8 minutes, 9 minutes.
Yeah, you are on time. You are on time. No worries. I have a question for you that the audience asked us in advance. So later on this webinar,
okay,
I
great.
will ask you that. Now I give the floor to Vasco. Please elaborate the mechanics of the employee stock option regime, the second subject of our agenda.
Thank you, Francisco, and thank you very much for inviting us to talk about this. Well, as we are trying to decode the law, the startup law, which the main advantage is to create, as Maria is going to explain, and the other panelists are going to explain, the main advantage is to create a tax incentive to the acquisition of shareholdings by employees in startups. Portugal Venture thought, and it was a good thought, that we should talk about the mechanism of the stock options programs, or the incentive programs based on stock options. And I want to frame a little bit what I'm going to talk. It will be challenged to talk about the mechanisms of the stock option programs in 8 minutes. I will try. I don't know if I can speak so quickly as Tiago, probably not, but I'm going to try to make the story short and to try to give some insights about the mechanism of stock options applicable to employees of startups. That's what we are going to talk. So I would say that a tailor-made definition of this kind of incentive programs will be an incentive program that is based on the allocation of shareholdings or rights over such shares, namely the right to claim a cash equivalent to those shares in case of the virtual stock option programs of a company that the shareholders have set aside previously, and to be assigned to future employees and collaborators of the company in the form of an option package based on a plan, which is the stock option plan, that will regulate the way which those options will be distributed and exercised. This is a long definition, but includes almost all the main concepts of the stock options incentives or the stock option plans, which are the creation of a stock option pool that we are going to talk, the dichotomy between the equity stock options based on real shares and the virtual stock options based on virtual shares or phantom shares as they already are known. Also, who are the beneficiaries of this type of programs, of these stock option incentive plans, the employees and collaborators. Also, the existence of the stock option plan, meaning that is the main regulation of the incentive program, and that will regulate the way this option shall be distributed. This is the stock options, as almost everybody knows, were created many years ago in the United States, not for startups, but for maturity companies. For startups, they have nowadays a huge relevance. They were imported from United States when the U.S. investors start to invest in European startups in a way that today, I don't know any financing, equity financing round where an equity stock option plan is not required by the investors. The main purposes of the stock option programs are very relevant for the life of the startups. First of all, is a tool to motivate the employees and collaborators to create value within the company, because they will share because they will be shall be allocated to them, to the beneficiaries of the options, the shares or rights over those shares. They would share later on in a short and medium term the upsides that that company will create. So this is an important factor to motivate employees, because they will create value in the company they work in. It is also a factor of attraction of talent and retention of talent, which is very important in the early phases of the startup life cycle, because it's the time to create and to consolidate high qualified teams, and to these key employees or high qualified employees that are needed to be engaged in this early stages of the startup life cycles, to give them options over shares or rights associated to shares in the company. it's decisively a factor of to attract them and to retain, as we are going to see with schemes that are classic in this equity, in this stock option programs that are, for instance, the vesting and other schemes. Another important purpose to use this stock option programs is to use them as an alternative to cash prices, what we call the cash performance bonus for employees of the company, of the startup already engaged, and also in the phase of engagement to compensate them, the offer of lower salaries without losing any competitiveness in the market, because the startups needed to allocate the funds they have available in the early stage to other things than engaging workers, mainly to the development of R&D and product. So it is in fact an important tool for the startups and to engage key employees and high qualified employees. Francisco, you can put the next. So what next, please, Francisco?
Yes.
Okay. So also two, of course.
One more minute, Vasco. I'm sorry.
One minute?
One last minute. Yeah.
Wow. Probably I'm going to surpass this, but two important concepts that are very relevant for the equity for the stock option programs is the difference between the equity stock option based on the allocation of real shares from a stock option pool. And they are based, of course, on the transfer of shares in the company. The beneficiaries of the options, or the beneficiaries of the stock options, will be granted real shares, and the virtual stock options that are, the virtual equivalent to the real shareholding, and entitles the holders of the options to claim the cash equivalent to the value of the shares. There is a lot of things to say about this. The virtual stock options are more often used because the beneficiaries are not real shareholders. They will have a right to get the results of a sale upon a liquidity event, or the equivalent of the value of the shares. But what happens is that they will not have any political, neither any economic rights on the shares, which is something that the founders are very keen to keep during the investment life cycle. So let's move it. So, and just to end, and very quickly, what I would like to give you, because it's the mechanism of startups have a lot of things and a lot of specificities, but I want to give you just a glance what is the life cycle of a startup stock option program. It started with the creation of a stock option pool, where the early stage investor and the founders most often set aside a percentage of their shares. They'll be diluted accordingly, and to create a stock option pool. And this stock option pool is from this stock option pool that the shares or the rights associated to those shares shall be allocated to the ESOP beneficiaries, to the beneficiaries of the options that will be elected under a stock option plan. As we said, it is the main regulation of the stock option program, where the provisions are the provisions that rule the mechanism of attribution of functioning of the stock option are foreseen. So after they approve this stock option pool and the stock option plan general are approved by the general shareholder meetings of the companies, And after this approval, it is generally the management that will grant the percentage of shares or rights to receive cash equivalent to the employees or collaborators that will be elected as an option package. Let me tell you that what are granted are options, meaning right to exercise an option to receive some shares or the proceeds resulting from a liquidity event from the sale of some shares. It's not shares itself, neither the proceeds, is options, meaning that the beneficiary of that option will have the right to choose if he wants to exercise the option or not. That will lead us to other things, but we don't have time to talk about strike price and other things. And just to tell you again, two more things about the life cycle. I mean, the beneficiaries will receive their options up front, of course, a percentage of the shares or the rights that will be entitled, but the company will maintain a forfeit right to keep those that will diminish over time through a process that called vesting, meaning that although the beneficiaries will get the percentage up front, they cannot exercise all the options at the same time. They will be the options shall be exercised during the years. Generally, commonly in Portugal is 4 years plus one cliff period where they can exercise the options, and this will to comply with the objective of retaining people. The consequence is that the non-vesting options, if there is a lever of the beneficiary, will cease to be to grant the rights that are associated to that. So
thank you, Vasco.
And that's it. I mean, if you want to, it's very challenging to tell.
I know. I'm sorry, Vasco.
In
Thank
8
you.
minutes, the mechanism is very cool, but I will be available for any questions that you may have.
In the end. Thank you, Vasco. We are a bit over time, but no problem. Bruno, should we move on to the benchmarking study?
Yes, sure. Thanks, Francisco. Good afternoon, everyone. It's with great pleasure that I'm here today with the remaining speakers to discuss this matter and try to decode at least a little bit more this new legislation. I'll try to make good use of my 8 minutes. But firstly, I would also like to start by thanking Startup Portugal, not only for the invitation and for organizing this webinar, but also for all the work that it has done during the, I would say, past 2 years to bring into force this new legislation and for letting us collaborate and participating in this journey that most probably has not yet ended and we'll still have a lot to do. In my view, the introduction of this new regime, it was a huge step forward in this very relevant matter. The use of share plans as a remuneration tool is already widely used through the world. Not only to startups, it's used regardless of the size of companies and sector where they operate. But of course, due to the special nature of startups, it's especially relevant for this type of companies. As I was saying, in my view, it was a really step forward, but there is clearly room for improvement. The legislation is not fully clear. There are several aspects of the legislation that should be clarified, should be improved. I would say that in some points, probably the final legislation didn't fully met the expectations. One example is the exclusion of board members or founders in some cases, not in all of the cases. But in my opinion, the overall balance of the introduction of this legislation is honestly very positive. Last year, during the discussions around the proposals for the new legislation, we have made an international survey using PwC International Network, covering 30 countries, with the intention of seeing what was happening in other countries with regards to these matters, and how other countries were treating from a tax perspective this type of plans. We have focused this survey on very specific points that were relevant for the discussions and the proposals that we intended to do in Portugal, and for the regime that we intended to implement in Portugal. Questions like the moment of taxation, if there was taxation at the exercise or only at the exit, tax rates, how the income qualifies, this type of questions. Already in 2023, after the approval of the Portuguese tax regime, we have made an update of the survey, and we have launched a second edition of this survey, already considering the new Portuguese tax regime, but also changes to other regimes in the other countries covered, like Spain, that also introduced a new regime. You can find easily this survey online, but I will go now very quickly through the main conclusions of this survey. As I said, we have covered 30 countries, all the EU, and also UK, Switzerland, and Norway. And I'll show you the conclusions on seven key questions around these matters. The first question was if the country has or not a special tax regime for share plans in startups. And we can see that 11 countries replied yes. So among these 30 countries, there are 11 countries that have special tax regime for the taxation of share plans in startups, including Portugal now. But from the remaining, 18 of the countries that do not have a special tax regime have, in a certain way, a favorable taxation on this type of plans. Of course, depending on some conditions, but they have any type of favorable tax regime for this type of plans. In some cases not focused on startups, but with a special tax stream. So we can see that almost all countries already have a special tax regime for this type of plans. Another important question is how does the income qualifies? Is it employment income, capital gains? On a standard share plan and using standard taxation rules, usually we have two types of income during the life cycle of a share plan. We have employment income at the exercise and capital gain at the sale. When there is a special tax regime, usually this changes a little bit, like it happened in Portugal, because in some cases we stop having two different moments of taxation and we start having only one moment of taxation, hopefully at the exit. And that's what we see here. There are 12 countries that qualify all the gain as capital gains. So these are usually countries that defer the taxation to the exit. There are two, one of them it's Portugal, that treat all the income as employment income. But in the case of Portugal, using a similar regime like the ones that treat it as capital gains, meaning that all the gain obtained at the exit is treated as employment income. This difference of qualification may trigger in the future some issues in situations of double taxation and application of double tax treaties. Then, when is the income taxed in the hands of the employee? We already referred this. Usually when there is a special tax regime, the taxation is deferred to the exit moment, to a liquidity event. and that's now the case of Portugal. And we may see that already a significant number of the countries, in this case 15 of the countries, only tax these gains at the disposal, okay, and not at the exercise. So as you can imagine, this was a very relevant improvement for the Portuguese tax regime. Next question is about the exit tax regime, if there is or not an exit tax regime. We may see here that like in Portugal currently, there are other 9 countries that also have an exit tax regime. These are usually countries that only tax the income at disposal, and as such they introduce these exit tax regimes with the intention of well, keeping some taxation rights on the country where the employee lived before leaving the country. So this is one of the points of the Portuguese tax regimes that of course triggers a lot of discussion, but it's also important to have in mind that countries with similar regimes like the Portuguese one also have this type of limitations. In terms of tax rates, on the 2 relevant moments, exercise and then at the disposal. At the exercise, we see that there are a lot of countries like Portugal that do not have any taxation, so there is no tax rate applicable, but there are still a lot of countries taxing at the exercise, and some of them with quite high tax rates, as you can see. Then at the disposal, next, yes, this slide. Most of the countries, of course, have taxation at disposal. We can see here 2 countries that do not tax at disposal. This is because they tax at the exercise, so they tax the employment income, usually with quite high tax rates, and they have then an exemption for capital gains. But in most of the cases, there is a taxation at the disposal, and as you may see, the tax rate in Portugal, an effective tax rate of 14%, so 28% on half of the gain, is, I would say, a very competitive tax rate, one of the lowest tax rates of all the countries covered. Then I believe there was still a question regarding social security. There are already a lot of countries that do not subject these gains to social security, like Portugal. This is clear in relation to equity settled plans, not fully clear on virtual plans, so that's a point that should be considered. But in summary, I would say that Portugal has introduced a very competitive tax regime, one of the 11 countries with a special tax regime for startups, taxation only at the disposal, at an effective tax rate of 14%, one of the lowest tax rates. There is, of course, room for improvement, as I said in the beginning, but I believe we started with the right foot.
Thank you, Bruno. We have to move on to the next speaker, but before that, let me ask you, how do you see Portugal ranking in comparison to other countries included in the study? As a concluding analysis of this study, can you point out if we are in the top 3 or the first third or something like that, comparing with the other countries?
It's hard to put Portugal in a specific place, because all of these regimes have, of course, a lot of conditions, a lot of details that are relevant. But I would say that, as we can easily see from these conclusions, Portugal has currently one of the most competitive regimes, at least within this group of countries that were covered by this survey. In the key points of these type of plans, like moment of taxation, it has introduced I would say the most beneficial solutions, and with a very low effective tax rate at the end. Of course, there are some details to improve, and Maria will refer some of them.
Yes, Maria, Let's move on then to your intrinsic insights over the ESOP, if you please.
Sure. First, my thanks to Startup Portugal and to all of you that are attending. In my 8 minutes, I have mainly two goals. The first one is to outline the tax regime applicable to option plans that was introduced by the new startup law. And the second, and probably more sexy, to address the most controversial topics that arise from the law. Bruno already unveiled some of the features or the main features of the law. But in the first place, I think it is very relevant, and my colleague panelists already focused, to have a preliminary remark on, I've heard some criticism on the law, which leads to some frustration, because although there is clearly room for improvement, of course, and some matters in the law are not completely clear, the recently enacted tax regime is clearly a step forward in the right direction and a significant improvement in the tax environment regarding equity incentive plans. It will certainly foster hiring and retention of talent. This is the key message, because I think that sometimes the media don't share the message accurately. As regards the tax regime, and very broadly, the new law brings two main positive outcomes. The first one is that the taxable event is deferred until the liquidity event. And therefore, in principle, the beneficiary, the optionee, will only be taxed when, and apologize for the expression, when he is in the money. So no taxation on dry income. And this was a situation that occurred in the past and that will still occur if the conditions for this regime are not met, because the standard tax regime will still be applicable, but preventing very unfair situations where employees sometimes were imposed to sell the shares to pay the underlying tax. And for sure, this is not the outcome that was desired, nor by employers when they grant this kind of benefits, or employees that benefit from the plan, because until now the taxation would occur on exercise and not upon a liquidity event. It is important also to focus that a liquidity event is typically the sale of the share or its underlying right, but the Portuguese legislation introduced two situations where that are treated as liquidity events. The first one is the change of tax residency that Bruno focused previously, that leads to an exit tax. So only the change of tax residency to another country leads to the taxation that would be due if the share or the right was sold in that moment. And the second one is where a free transfer takes place. But typically, I would say that 95% of the cases will equate a sale to a liquidity event. The second, and also important, and also already brought by Bruno, is that the new tax regime qualifies the income as employment income, but at a very attractive rate. So the income is subject to a 28% rate, but only considered in 50% of its amount, leading to a 14 effective tax rate. And please recall that the 14 tax rate is in Portugal the most reduced tax rate that applied to capital gains. Okay. Secondly, the regime is subject to a condition, and the condition is the maintenance of the rights or shares for a minimum period of 1 year. So if this minimum holding period is not met, the standard tax regime will be recaptured and the taxation will follow the standard and previously applicable rules. Second, which is the scope of beneficiaries that can be included within the new law. First, Portuguese tax employees, excluding shareholders that hold directly or indirectly 20% of more of the share capital of the attributing entity, and also the board members of the attributing entity, with two relevant exceptions. When the attributing entity qualifies as a startup or a micro or small enterprise, those shareholders holding more than 20%, as well as the board members of the attributing entity, also qualify for the purpose of the, well, tax incentive, let's call it this way. The regime is in force, was enacted in the 2026 or of May this year, but it will be in force with effects since the 1st of January this year. Next, please. Thank you, Francisco. Having introduced the outline of the regime, I think that there are some notes addressing some topics that are raising controversy. The first one is the scope of eligible entities. So which entities are eligible? I've probably, some of you may have heard that the scope of eligible entities would be rather reduced, and therefore that the law would not have a very relevant and useful effect. I could not disagree more, because the scope, if as a principle the law was aimed to meet startup needs of hiring and retention, the truth is that the final version that was adopted includes a wide range of entities. So this is a misconception that must be clearly erased from our thinking. So which are the entities that are included? Startups, as defined previously, micro, small, and medium entities according with the EU standards, small mid caps, which are also qualified under EU standards, but I think that we are less familiarized with the concept. This is a company that it is already a large company because it exceeded the thresholds of medium companies, but individually it has less than 500 workers. So I would say that probably 98% of the companies in Portugal could be considered as eligible entities, and therefore the scope is quite broad. Also, innovative companies are, regardless of their size, are included. What are innovative companies? Companies that have R&D costs that are at least to 10% of their costs or turnover. A second question that is raising a lot of debate is the situation where the attributing entity, which is a totally new concept introduced in the law, is whenever the plan is set up at the level of an entity which is not the employer of the beneficiaries. Well, in this case, I think that a case-by-case analysis is required. Because, first of all, an associate company, regardless of the geographic location, is considered for personal income tax purposes as an employer. This is already addressed in the personal income tax for several years, so it should not be a controversial topic. However, this criteria or this concept, the notion, was not introduced in the law, despite notably Startup Portugal has asked for such clarification. And having this said, this may raise some debate on whether these situations are included. First of all, the accounting records are very relevant because
Maria, in 1 minute, I'm sorry, 1 minute, okay?
not possible.
2 minutes, let's say.
Please do.
Okay. Okay.
First of all, accounting records will be extremely relevant. This kind of plan should be accounted for under IFRS 2. And in principle, the receiving entity, this is the entity which receives services from employees, is required to account a cost at their level. So in principle, at least for economic purposes, the cost is accounted for at the level of the entity. But then a new notion arises, which is, who is the settling entity? Who is the entity which bears the economic effect, the financial effect of the plan? And where the parent company does not recharge the amounts to its subsidiary, there may be some doubts on whether this should be treated as an attributing company. Second, and Vasco already explained the difference between a virtual stock option plan and a physical stock option plan. There were some doubts on whether the virtual plans were considered in this law, and in fact, in the first draft of the law, it wasn't clear if the virtual plans were included. But in the final version, the law included the expression rights of an ideal nature to physical shares. And therefore, it seems that there should be no room for doubts on whether such plans are included, notably because they represent the large majority of the plans that are in force in Portugal. Finally, regarding the date of approval of the plan, this is also, there is a transitional provision that seems to exclude plans that were approved prior to 2023, except when the attributing entity qualified at the day of the plan's approval as a startup. However, one could say that there should be no clarification regarding the other entities, as the concept of small, medium, etc. was already addressed in the law, but this is not crystal clear and should be clarified in the law. And just a final remark to address a topic that refers to the fact that the law seems to have created a loophole regarding newly incorporated entities. This because the eligibility of the entity must be verified in the year prior to the plan's approval. Well, if the plan is approved in the year where the company was incorporated, they cannot fulfill the criteria because simply they didn't exist. And this is also something that must be clarified in the law. The time was short. I know that I exceeded a bit. I hope to have addressed some of the questions, and I remain available.
Thank you, Maria. With no time to lose, I will pass to Paula and Marisa. Let's now move to the last subject of our agenda, the so-called SIFIDE fiscal scheme. So please, Paula, Marisa, take the stage.
Thank you, Francisco. Good afternoon to you all. It's really a pleasure to be here today with my colleagues panelists to share with you our perspective on the main impacts that the Law 21 from last May brought to the SIFIDE regime. But before getting started, of course, we have to thank to Startup Portugal for inviting KPMG to address this topic. So, SIFIDE regime, to some of you who eventually do not know, we will start with a quick presentation of the regime, okay? And then move forward to the novelties of the law. So the SIFIDE tax credit is a benefit that is in Portugal since 1997 that aims to stimulate the development of R&D activities in Portugal. Under this regime, the Portuguese companies may benefit from a tax credit that may go up to 82.5% of a tax credit assessed based on the eligible R&D expenses. But how do we access that tax credit? We have a base rate of 32.5% of the expenses that are incurred in the tax period, and we can add an incremental rate of 50%. That refers to the increase that we have from the 2 previous years of expenses with R&D. Of course, we are making some general appointments. We have some specificities that you have to see in the regime, okay? But generally, so what are we able to see as the main expenses, eligible expenses that our clients and the companies here in Portugal present? Expenses with qualified human resources allocated to R&D activities, the hiring of R&D activities to entities that are recognized in specific fields of R&D by the competent authorities, in this case, Agência Nacional de Inovação, the acquisition of new fixed assets in its allocation to the R&D activities, and also mainly since 2017, we see entities that contribute to investments funds that invest in equity and quasi-equity of companies that are recognized as R&D entities. Also, you can find overheads that can go up to 55% of the expenses with qualified human resources allocated to R&D activities, among other expenses that you may argue to be linked with the R&D projects. Of course, to benefit from this tax regime, you have to submit an applications within the legal deadlines, and of course, complying with the formalities that you have here in Portugal. So what are the main novelties that we would like to share with you, okay? You had in this law the increase of the percentage points in the surcharge that is applicable to expenses related to R&D activities for eco-design projects for products. What we say is that now we consider 120% of those expenses as eligible and not 110%, okay? At this stage, we will be able to have 12 years of validity from the recognition as R&D entity, okay, in the practice of R&D by Agência Nacional de Inovação instead of 8 years as previously. And also, we will be able to carry forward the tax credit that is not deducted due to insufficient CIT assessed during 12 periods instead of 8 years periods, as was previously foreseen in the law. Okay, so Francisco, could you please move forward? Okay, next slide. Yes, thank you. As mentioned before, since 2017, we had a strong increase in the expenses related to the participation in contribution to investment funds that are able to invest in equity and quasi-equity of companies that are engaged in R&D activities, okay, and have that recognition to perform R&D activities in certain fields of expertise. Thus, in the last years, we have seen that the law has been changing and has moved to ensure the control of those investments and those expenses as it is being used by the companies. So in these amendments introduced, we can say that as main amendments, the fund holding units can only be sold after a 10 years period from the acquisition date. Okay, we have an enlarged of 5 years from the detention period of that unit. Okay, also the funds will have to invest within 3 years instead of 5. 85% of the investment that they receive from companies in those R&D entities instead of 80%, okay? Also, what we can see is that entities that will receive from those funds amounts to invest in R&D will have a 3 years period from the date the funds give them the money to invest that amount in R&D activities, okay? Previously, we had a 5 years period, okay? One relevant change also in the law is that foresees the non-application of that increasing rate that I mentioned before of 50% of the tax credits that would be assessed based on the increase of expenses in comparison with the simple arithmetic rate average of the 2 previous years. Okay, this will not apply to this specific eligible expense of the SIFIDE tax credit. Okay. And finally, of course, we can, although you have here also in the slide, we can emphasize that it's foreseen that companies that will receive that amounts from the funds to develop R&D activities will not be able for those specific expenses that are covered by the funds, not be able to benefit from SIFIDE in case, of course, the holding unit's acquisition was already eligible for the SIFIDE tax credits. Okay, there's also an anti-avoidance measure that is foreseeing that expenses, if you have a special relation between the investment fund and also the management company, of course, you will also have the non-eligibility of this kind of expenses. Okay, and trying to stick with the time. Okay, I'm looking at my clock. Okay, what I would like to say is that these amendments to the investment tax code are effective only on the 1st January 2024, of course, with one single exception. That was the one that I mentioned before, that refers to the time frame that the companies that are dedicated to do R&D will have to invest the money in R&D expenses. That particular change is effective from the 1st January 2023. And I will say that I will end my presentation because I'm sticking with the time, Francisco. Thank you all for
Paula.
your attention, and we will be glad to answer any query. Thank you.
Thank you, Paula and KPMG team. We are overcoming our time, but still, with no further delays, I want to ask you a few questions that the audience asked us in advance. So, starting with the KPMG team, the question is, does a company that it was invested or that receives investment from a fund become ineligible to apply for SIFIDE?
Okay. So what's foreseen is that from the 1st January 2024, companies that will receive the money from funds that previously, when the acquisition of the units generated a tax credit in the participating companies, the same amount will not be benefiting from the tax credits. It's an anti-avoidance, let's say like that. It's trying to non-duplicate the tax credit effect, okay, in the participating entity in the fund and in the entity that will receive that money from the fund. So what it will have to be seen is that if the entity that is participating in the fund is benefiting from tax credits of SIFIDE, then the entity that will receive that money from the fund, the company, okay, that is performing the R&D, will not be able to benefit from the SIFIDE only in respect to those same activities, let's say like that. We believe that's the interpretation that we may have from the law. We will not be able to benefit from the tax credit only in those expenses, okay? Otherwise, imagine for the expenses that are apart from that funding, they can get some SIFIDE. It's relevant so only to notice that, of course, some communication obligations are foreseen in the law to allow this monitoring, okay, by the entity that will receive the funds, for her to know if it will be possible or not to benefit from the SIFIDE. Thank you, Francisco. I hope to have clarified.
Thank you. It was, I think it's now clear. I have another question now for Tiago, and it's one of the questions that our ecosystem or the community approaches us several times. So how can I preliminary communication? How can I do the comunicação prévia, preliminary communication to start up Portugal in order to get the recognition?
All of the procedures for comunicação prévia and the other procedures, they should be addressed at the platform that is going to be delivered according to the administrative guidelines that is under development by the government. So I would say that at this stage, it is just to be aware to the requirements that needed to be fulfilled, that requirements are within the law, because the ordinance that is going to be developed by the government, it's going to be made according to the framework that is already defined. So I would say that this is the point. Of course, it will have to wait until the deadline that I said, that is that this period of standstill that is going to end at 25th of November. After that, it can be addressed. Okay.
Okay, Tiago, from the chat, we have a question asking if a spin-off company can be also a startup.
I hope so. I think this is the most important. That I think everybody that have spoken hopes so. So yes, the question is not can it be? Of course it can. The question is does it fulfill the requirements or any constraints that may limit the classification? Okay, so this is something that should be addressed, because what the law and what the legislator, my interpretation, of course, try to avoid is companies that try to create split-offs of a business that already occurred just to gain this kind of procedures. So, of course, we have to think in the framework that are always checks and balance. So, of course, a company within the requirements may be certified as a startup, but it should be evaluated if there is if all the requirements are fulfilled, because if they aren't, it cannot be classified. So a split off can be, but nevertheless, it has to understand if there is, for example, if it is owned by a large company with more than 250 workers or more than 50 million euros of turnaround. That are the limitations.
Okay, question now to Maria. Someone from our community has a stock option plan from a company, like within the group. He is employed in a company, in a Portuguese company or based in Portugal, but the share plan is from a parent company out of Portugal. Is this how this law address this situation? How can it be? Can they benefit from the stock option?
I would say this is the $1 million question within the plans in international groups, and there is no clear-cut answer to the question. What must be clearly verified is if the plan is accurately accounted for at the level of the subsidiary, whether the subsidiary bears or not the cost of the plan in its own accounts. If the amount is not recharged from the parent company to the subsidiary, one could still verify whether the parent company would verify the criteria to qualify also as a tributing entity. Notably, and I would say that within the European Union, this should be completely straightforward. And even outside the EU, and in similar provisions, which are not the provision that is the one at stake, but regarding the application of the reduced tax rate in the sale of shares, companies which verify the criteria that are addressed in the law, even if they are not resident in Portugal or in the European Union, should benefit from the tax regime. So I would say that although the Portuguese tax authorities may and will likely raise issues in this topic, there are a lot of arguments to sustain its applicability. Of course, this is not crystal clear, and I think that it will still be subject to discussion. The question of, sorry, just a small remark, the entity within the group being qualified by the Portuguese Personal Income Tax Code as employer is a very strong argument, because I would say that it would not be reasonable from a systematic standpoint to have two different concepts of employer entity as regards personal income tax, whenever this is not beneficial for the taxpayer.
One last question from the chat. Tiago, he has a stock option plan with a startup company based in Germany, and he's a remote worker resident in Portugal, and he's asking if he can have access to the 14% tax rate at disposal moment. Vasco, do you wanna answer this one? Or Maria or Bruno?
I can address the question. Yeah. I think it's more tax related than corporate.
Yeah, exactly.
The concept of startup requires either the company to have head office in Portugal, which would not be the case, a permanent establishment, also known as a branch, or 55 workers. So I would say that under the definition of startup, the entity would not qualify. But this does not mean that the entity could not be, the attributing entity, the German entity would not qualify as a micro or small or medium or small mid-cap entity. And within the European Union, and recapturing the argument that I pointed out before, I would say that although the law probably was, or the rationale was to address Portuguese-based companies, we could not treat a worker from from a company employed in Germany, in this case, treated differently. So I would say that it should apply. It may be not crystal clear, but from a substantial perspective, it should apply. Yeah.
Thank you, Maria. Thank you all. We are 15 minutes ahead of our time. I hope the session clear up some of the doubts of our audience, and give some good insights over the new startup law. And I hope you have a good rest of the day, rest of the afternoon, and thank you all, you experts, and on behalf of Startup Portugal, we are happy, and it was a pleasure to have you all here. Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye.
Thank you. Bye-bye.